I'm Jonathan Saltzman. I'm a reporter for the Boston Globe. I'm writing a story about a ruling by the state's highest court today about GPS devices being worn by convicted sex offenders. This case stems from a horrific crime that occurred in 1990 where a man abducted a little kid, a 7-year-old boy, at a Portuguese club in Lowell, and then took him to an area under a bridge and raped him, and then took him back to his house and then did the same thing, and then kept him for a number of hours, and then deposited him in a box the following day, and then summoned a cab and had the cab drive the kid home. The guy, his name is Ralph Goodwin, and he spent about 20 years in the state prison as well as the treatment center. Prosecutors asked a judge to change a number of the conditions of his probation, and after he had been released. And after, at that point, he hadn't done anything wrong in terms of violating the conditions of his probation. One of the things that they decided they wanted to do was order him to wear a global positioning device. And the reason they did that was because a few years ago, in 2006, the state passed a law requiring that all convicted sex offenders wear GPS devices so authorities can track their movements. But literally last year, the state's highest court said you can't do that to people automatically who had been convicted before the law went into effect, which was in 2006. So essentially the state's highest court set some limits last year. And then what happened in today's ruling was the court said you can't require somebody to wear a global positioning device, a GPS device, if they haven't violated the terms of their probation. And that applies to anybody who was convicted before the law went into effect in 2006. And that's the case of Mr. Goodwin. And the court has concluded that these devices are punitive in nature and they restrict someone's movement. And so unless they've done something to violate their probation, you can't just unbidden require them to wear it.